Hi, Kaylin. We want to thank you for coming today. The reason we've asked you to come is because you're an experienced attorney, that you graduated from Grand Valley State University, and this tape is being made for Grand Valley State University students who try mock arbitrations. They know that the arbitrations are not going to have rules of evidence, but they also know that the arbitrator is going to expect some objections. And so we'd like to go through some basic objections that you think are common in arbitration. But before we do that, I'd like to know a little bit about your background beyond Grand Valley State University. Where did you go to law school?
I went to law school at Michigan State University.
And you did also a master's, did you not?
I did a master in labor relations and human resources, also from Michigan State University.
So you're a true blue Spartan.
I am, but I'm also a Laker.
Now, you work for a local law firm in Kalamazoo, and which law firm is that?
Miller Canfield, Paddock and Stone.
And what kind of law do you do there?
I'm in the firm's labor and employment practice group, and we represent employers only against employees, for instance, and against unions.
Okay. Now here I see up on the board, if you don't mind, I see that the first thing that is written is relevance. Why is that an objection?
Well, relevance is probably one of the most common objections, and the purpose of that objection is that the answer to the question would have no bearing or would be of no consequence to the case at hand.
So let's say that there's an arbitration about overtime, and I want to bring up things about somebody's personal life just to get back at them. Would you claim relevance as an objection?
Absolutely. Once the question is asked, then the opposing counsel or the opposing advocate should say objection, relevance. And at that time, if the true purpose of the question is to get back at the person, then yes, most likely the answer or the question would be irrelevant. However, sometimes it might be relevant depending on the case and the circumstances involved. So once the objection is raised, then the party asking the question at that time has an opportunity to explain to the arbitrator why the answer would be relevant, and the arbitrator should make a decision as to whether the question was appropriate or not.
Would you say that arbitrators are pretty lenient about relevance?
I think they usually are. In arbitration, there's no jury. It's just an arbitrator who will be making the decision, and because arbitrators are more akin to judges, where they have the experience, they are generally more able to distinguish the testimony or the evidence that does or that is consequential to the case. And so with regard to evidence or testimony that is irrelevant, the arbitrators are able to put that out of their mind or not take that into account when making their decision.
Great. Now, if you could step back a little bit, I just want, here on the board, we see hearsay, and then we see one person talking to another, and then underneath that, we have the truth. What does all of that mean? Hearsay, people talking to each other, and then the truth. Is that an objection?
Yes, it's also definitely one of the more common objections, and the purpose for this objection is that the answer would have to be hearsay, which means if you've ever played the game telephone as a kid, where the first person whispers something into a recipient's ear, and then that person goes to a third person, so on and so forth, and by the time it gets to the end, the actual statement that was made is so different from how it originally started out that the testimony would be unreliable if you want to look at it from that standpoint. So basically the answer would be, this would be the person answering the question. This person would be testifying to what this person said. And so if you go back to that telephone game, you can see where the further it goes down the road, the less reliable the actual testimony would be.
Now let me ask you this. Let's say that there's a letter that somebody wants to put into evidence, and they don't have anyone to testify as to the letter. Or you have a picture that somebody took and you don't have anybody to testify as to the picture. All you have is someone saying, well, I heard that John took that picture. Is that an example of hearsay?
Yeah, especially with regard to a letter, because the legal definition of hearsay is that it's an out-of-court statement that makes an assertion which is offered into evidence to prove the truth of the matter asserted. So it's likely that the letter is going to posit some factual assertion that will be offered into evidence to prove the truth of the matter asserted. Obviously, it was made out of court because it was typed on a letter outside of the hearing, or so that would definitely be an appropriate basis for a hearsay objection. Now, there are some exceptions to the hearsay rule, one of them being, for instance, a business record exemption. So if the person offering that letter into evidence can meet the standards for the business record exemption or exception, then the letter would appropriately be admitted into evidence. With regard to a picture, I'm not sure that hearsay would be an appropriate objection because it doesn't really posit a factual assertion.
Might it be foundation then?
Yes.
Okay. Why don't we go over to foundation, which is over here, and I noted that here with foundation, we have a house, and then you see the foundation underneath the house, and it says must have foundation in order for the house to stand. What does that have to do with an objection in arbitration?
Well, the person testifying or the piece of evidence that you want to offer in,
Like the picture?
like a picture, has to have some sort of foundation, otherwise it's just not going to stand. It's just going to fall down and crumble.
Why?
The person who's testifying needs to have personal knowledge about what he or she is testifying to. Or like the picture, if nobody knows when it was taken or who took it, then it's likely not going to have any foundation. We need to have some foundation to back up what is being said. So for instance, if somebody asked me, what did Star Swift have for breakfast this morning? I could make up some answer, but an appropriate objection would be foundation. This witness has no personal knowledge what Star Swift had for breakfast this morning since I wasn't there when you ate breakfast.
Or if I show you a picture, or I show the arbitrator a picture, and I don't have anybody to say when they took it, how they took it, the date they took it,
Right, with what camera they used to take it.
then that's a foundation problem too.
Yes.
Okay. Up there I see you have leading the witness and you've got a person leading a dog. What's the problem with leading a witness in arbitration? Why would that be an objection?
Well, a leading question is one that suggests an answer. It's inappropriate to lead your own witness. When you're questioning your own witness, you have to ask non-leading questions or direct questions, ones that do not posit or suggest an answer. The purpose.
Now, I just have to interrupt you. Why not suggest an answer to your witness?
Well, that's because if an attorney or an advocate posits an answer within the question, then it's deemed almost that the attorney or the advocate is actually testifying rather than the actual witness testifying.
So I couldn't say something like, on the 3rd of November, you were sitting at your desk and you saw John take the money out of his desk and give it to Sue.
Well, you could ask that if you were cross-examining someone, and it's appropriate to cross-examine someone when it's not your own witness, when it's not a witness that you are producing.
But I couldn't do that for my own witness. For instance, I would have to ask then what happened on that date and allow them to testify as to what happened.
That's correct.
So I guess what you're saying is leading the witness is like testifying for the witness, and you can't do that.
That's correct.
Great. Now I want to go over here to asked and answered, and then I see it shows an arbitrator who says, stop the madness. What's that all about?
Well, what happens sometimes in arbitration hearings is that the person asking the question, the advocate or the attorney asking the question, is not happy with the answer that he or she receives from the witness. So sometimes that advocate will ask the question again, usually in a different way, using different words, or sometimes even the same way, the exact same question, just at different points in the arbitration hearing, just to try to see if he or she can get the answer that he or she wants, or to see if the person will change his or her answer so that the person asking the question can show that the witness is a liar.
And you can't do that.
You can't do that.
Okay, once you've asked it, it's been answered, that's it.
That's correct.
Can you give us some advice on where to get more information on
Sure.
arbitration?
Yeah, I would definitely check out Grand Valley State University's arbitration website. It's an excellent resource.
Thank you.